So again, my name is Dixie Newnham. I am with Newnham Land, and this is the fifth presentation we've done in this series on wills, trusts, and powers of attorney. Today, we will be focusing on probate matters. And so, as I've told you at the beginning of other presentations, this is purely for educational purposes. Each person's circumstances are different. And so if you have questions regarding your specific circumstance, you should consult an attorney of your choosing. And sorry, there's someone trying to get in from the waiting room. And for some reason, my computer's having a hard time letting them in. Sorry about that. So we will go ahead and continue on. So like I said, we're speaking about probate today. And so what is probate? A lot of times you hear this term kind of thrown around, and if you haven't actually experienced a probate before, it can seem cloudy as to what exactly that is. So today we will go through what exactly a probate is and some administration basics. And by going through the administration portion of it, it tends to enlighten a little bit more about what exactly probate is. We will also talk about why you would need a probate, some of the basic types of probate, and then possibly some strategies for avoiding probate. That last category will be pretty short because we've covered that in the other topics that we've covered during this series. So for example, I've touched on this topic in the wills presentation, the trust presentation, and the beneficiary presentation. But we will touch on it again today, just as a little bit of a refresher. So what is probate? Probate is a legal process involving the court that takes place after someone dies. So I know that also is about as clear as mud, right? Without understanding what exactly the process is. So we will walk through that process and we will touch on proving that the will is valid in court, the appointment of the executor or personal representative, identifying and inventory in the deceased's property, the payment of their final debts, and distribution. So really those 5 topics that we're going to cover encompass really what probate is. And I think by walking through these, you're going to have a little better understanding of what exactly probate is. So let's start with proving up the will. What does that mean? So there has to be a process by which a will is proven to be valid. I think most of us understand this intuitively, that we can't just necessarily accept that a will that someone has found is a valid will or a final will. There has to be some sort of method that you actually prove that the will is the final wishes of the person who wrote it and that it is legally valid. So for example, without going too deep into this, a will that is half in the handwriting of the person who made it and half typewritten may be partially invalid. A will that is all handwritten may be completely valid, but there's got to be certain things about the will legally that make it valid. And so the reason for that is our laws are interested in making sure that when someone shows a will, right, in particular one that's going to benefit themselves, that really is the final wishes of the testator, because the testator, the person who made the will, is no longer alive to express their wishes. So what is that process to prove that the will is valid? Well, that involves the court. So most wills that are drafted by an attorney will have some language similar to this one you see on the screen here, this self-proving affidavit. So most wills that are drafted by an attorney include this language as well as, or similar language, as well as the signature of the person who made the will, 2 witnesses, signatures of them. So watch the person who made the will sign. They testify under oath by signing this affidavit that they watched the person sign, the person was over 18, the person didn't appear to have any sort of disability, and the person didn't appear to be under duress in making the will. And then all of that is signed by a notary. So to show that these people were all in the same room, we're all watching the same thing going on. And so wills that have that are actually the easiest to prove. So how do you prove them? Well, you prove them by submitting the will to the court. Okay, so the court ends up being the place that adjudicates or decides whether a will is valid. So once someone dies, you take their will, you file it with the court. When you file it with the court, you also file it along with some other paperwork that says, I believe this to be the last will and testament of the deceased, tells when the deceased died, some other specifics about where the deceased lived. And then the court holds a hearing at which the person who submitted the paperwork shows up and testifies to all of those things. They testify to when the person died, where they were living, and that they believe this to be the last will and testament of the person who died. Now, some states truncate this process a little bit and allow the person who is submitting the will to the court to just sign an affidavit without ever having to appear in court. In Texas, you actually have to appear in court and prove up those things, prove up that you believe this to be the final will and testament of the testator before they will actually admit it to probate. So once you do all of these things, the court will then admit it into probate and you're kind of off and running. But you may ask yourself, so what happens if there's no will? Well, if someone dies not leaving any final writing of what they wanted, in that instance, you end up in this situation. You end up in an heirship proceeding. So I hear a lot of times from clients that they're concerned that without a will, all of their stuff is going to go to the state. That's highly unlikely because by statute, if you die without a will, there's a whole tree of people that your stuff should go to. So that's what this chart shows here. And that tree involves current spouses, children. If there's no current spouse, no children, then it includes siblings, parents, and it's basically your family tree. It starts looking for people who are related to you by blood, with the exception of your spouse, and trying to give that stuff, give your belongings to those people. All right. So, but how does a court know who these people are, right? And, or how does anyone in the world know? So if you die without a will, again, you have to have a court proceeding initiated by someone who then goes into court and they testify. But this time, instead of testifying that the will is the last will and testament of someone, because there isn't a will, they end up having to testify as to who the family members are. So if you've seen our previous presentations, I've used this picture here to represent my own kids on various occasions, but that's meant to represent the family members of someone who has died without leaving a will. So probate can also be the process by which you determine who should get the deceased's belongings if they did not leave a will, or if a portion of their will is invalid. So you may be asking yourself, who in the heck does all this, right? Who is the person who physically files this with the court and then shows up to the court to testify? Well, that person is usually your executor if you have a will. So in this example, there is a will executed by John Doe, and he nominates his wife, Jane Doe, as the executor. And so as the executor, usually that is the person who ends up submitting the paperwork to the court to initiate the probate and then testifying that this is the last will and testament. So now you may ask yourself, well, what about the previous example where there's no will? Who would do it then? By statute, there are people listed out that have priority on who can be the executor, or sometimes called the personal representative of the estate. And so oftentimes it will end up being maybe a beneficiary of the estate or a child, a brother, a sister. Usually it's someone who has some interest in making sure that the deceased's belongings pass the way they're going or are supposed to pass. So it can even involve creditors. If there is an estate in which there is a significant amount of debt and there appears to be assets to actually pay that debt, maybe it's a creditor who ends up bringing it. But usually it is someone related to the individual who has died who has some interest in clearing this all up. So the executor submits the paperwork to the court and they have a hearing. The executor testifies, and then the court issues something called letters testamentary, or sometimes these are called letters of administration, depending on the type of probate proceeding that you're doing. But it's these letters that give the person who is submitting all this paperwork the authority to move forward and handle the affairs of the deceased. So oftentimes I'll hear this question, or I'll get this scenario in my office. A client will call me and tell me that there's some life insurance out there and they've called the life insurance to let them know that the deceased has passed. And the life insurance company will say, can't talk to you, not going to tell you a thing about this policy until you can send me letters testamentary or letters of administration. And so what the life insurance is doing, or sometimes it's a bank, right, or an investment company, what they're doing is they're saying, we're not going to talk to anyone until we know they have been authorized to act on behalf of the deceased. And so they are looking for the court's approval that you can act. That's what these letters testamentary are. So you've gone to court, you've proved up the will, and you are ready to, you've got your letters testamentary and you're ready to move forward. So the next step in the probate is to notify heirs. Okay, what does that mean? Anyone who may receive something under the will or who may receive something by intestate descent, that's the chart down there at the bottom with all the circles, right? That's someone who died without a will. All of those people are entitled to know that there is a probate proceeding pending and that they might have an interest in the probate. So I think it's pretty logical why you need to take that step. As you're going through this process, you want to make sure that if anyone contests this, anyone contests what's going on in the estate has to come forward, right? And they have to let people know that they've got some interest in this estate or be barred. And the reason for that is pretty simple. You don't want this stuff just hanging out there forever, popping up, years down the road, right? And so these people have a right to know that there's a probate occurring and who is in charge of administering the estate, either the personal representative or administrator. So you provide them notice that this is what's going on. There is a probate pending, and you know that you are either an heir under a will or maybe by intestate distribution, but you need to know that you may be entitled to something at the end of this. So we're going to switch gears a little bit here. So up to this point, we've been talking about all the stuff that's happening within a court proceeding, okay, which is technically called probate, right? So some of this next set of things we're going to go through will actually apply not just to probate, but if someone had to administer an estate that existed under a trust, okay? I'm not going to go too far into that, but just understand that if someone becomes a trustee under a trust, they can bypass potentially those court proceedings, but they still have to administrate the trust, meaning manage the property, pay debts, and make distributions. So we'll be talking about this within the context of a probate today, but just know there is a little bit of overlap on the administration side with a trust as well. So what do I mean by identifying property? When someone passes, right, and you've gone to the court, you've been approved under the will, you then have to figure out what they owned. Sometimes that's fairly simple. It depends on your relationship with the person, right? Sometimes it's fairly complex and complicated. Sometimes the deceased hasn't really told people what they own, right? Have been very careful about who knows about their finances. In those instances, the executor or administrator really has their job cut out for them because they end up having to dig through the paperwork of the deceased to try to find what assets they owned or didn't own. And so just as an estate planning technique, Your executors or administrators will really appreciate it if you keep somewhere a list of what you own and what you owe. If you do that, it makes the lives of your administrators so much easier. Just some food for thought. So, identifying property. What is property? Well, it could be house, it could be real property, it could be a condo, timeshare, cars, vehicles, boats, motorcycles, bank accounts, investment accounts, where anything in which people are keeping or holding their money, mineral interests. You see a lot of mineral interests down here in Texas. And those can be complex because people's desire for them really fluctuates with how well that market is doing, by the way. Promissory notes. So when I say a promissory note, this is not a promissory note that the deceased person made to someone else, but it is money owed to a deceased person. So if at the time of your death, someone owes you money and you are the holder of a promissory note, that actually becomes part of your estate to be collected or managed. Stocks, bonds, those can all be part of the estate. Cash money, another little aside on the keeping a list of things for your executor to know about. If you are someone who tends to sort of squirrel away money in different places, let someone know. I joke a little bit that I advise clients to give people the treasure map, right? But if you have the sock drawer that's got a bunch of cash, rainy day cash in it, or wherever, the shoebox, the mattress, buried in the backyard, you need to let someone know about it. Otherwise, it's never, chances of it being found are pretty slim. And if someone does an estate sale or gives away property, there's a chance they're going to be giving away some cash with it. So if you have any significant amount of cash that's not hanging out in your wallet, let someone, person who'd be taking care of your estate, knows that that exists. And then finally, the gravy boat. So I laugh about every family has that one item that has very little financial value to it, but a lot of sentimental value. So in my family, it was my great aunt's gravy boat. And it looked quite similar to that actually, but that's meant to represent all of your personal belongings. That too is part of the estate. And that needs to be safeguarded once you are appointed the executor or the administrator of the estate. So it is not uncommon, in particular with families that maybe have some disputes going on or some kind of acrimonious relationships. It is not unusual for someone to come into the deceased's house, start grabbing the stuff they want, and then get out of town while people are at the funeral or preparing for a funeral or grieving. And so, as the executor, you really want to, even before maybe court appointment, take some action to make sure that the personal belongings are not disturbed until you have a chance to actually get everything sorted out and go through the process. Now, there are some temporary measures you can take through the court if you have a situation like that to try to stop it. But just be aware that that is a dynamic that's out there. And like I said, sometimes the gravy boat ends up being the thing that's most desired and fought over just because of the sentimental value. So once you've identified the property, if you're going through probate, you have to do what's called an inventory. In Texas, it's called inventory appraisement and list of claims. And what this is a list of things that the deceased owned. So most of the time, this is filed with the court. There are some options where you don't have to file it with the court, but a lot of times it is, just for ease of administration. And so what you're listing here is all the property that the deceased owned. Now, that is part, let me clarify that. All the property the deceased owned that is part of their probate estate. So what the heck do I mean by part of the probate estate? If you listen to some of my previous talks, we learned that certain things like beneficiary designations, that's probably the biggest one, or ownership with right of survival can take property out of the probate estate. So if something has a beneficiary designation or is owned jointly with a right of survival, it passes directly to that beneficiary or that joint owner without becoming part of the estate. So that means that beneficiary designation or that joint ownership with right of survival trumps what is in the will. So if it's not part of the estate, it shouldn't be part of your inventory. So, well, let's talk about this because this becomes pretty important depending on the dynamics of your family. So let's take an example. You may be thinking to yourself, well, how important is it really to understand what goes into a probate estate and what doesn't? So let's say that John Doe died, right? And he left everything to his wife. But if his wife predeceased him, he left everything else to his descendants per stirpes. So what descendants per stirpes means in a very shortened form is equally to my descendants, to my kids. So in this instance, equally to my kids, let's say John Doe had 2 kids. There they are. And so whoever the executor is for John Doe has filed an inventory that says that there are stocks and bonds in an Edward Jones account of 63,000. So for purposes of this example, we're assuming that wife has already died. So the kids are looking at this going, great, we're going to inherit $63,000 between 2 of us. So we're looking at $31,500 ish each. Fantastic. But let's say that John Doe had a beneficiary listed on this account. And let's say that beneficiary was a woman that he was familiar with after his wife died, but wasn't his wife. Because of that beneficiary designation, that Edward Jones account would go to this lovely woman over here versus the kids. Well, the kids are going to be shocked and dismayed if they have seen this inventory and thought that that account was part of his estate and that they were going to get half of it. So instantly that breeds fighting and distrust of the administrator or the personal representative. So it is much better on the front end to be clear about what is part of the estate and what isn't, so you don't create misconceptions that then have to be cleaned up. Now, in this instance, let's say you did put the stock or bonds on here, the Edward Jones account, and it did have a pay on death beneficiary to this lovely woman. You can fix it, you can amend the inventory, but some of that ill will kind of stick around. So if you can get it right on the front end, is certainly helpful. So once you've identified all of the property that's part of the estate, you need to then identify the debts that are owned by the estate. Sometimes it's pretty obvious, right? So, as the executor, you're picking up mail, right? You're looking through financial records and you're seeing maybe credit card bills or notes. Maybe you know that there's still money owed on the house. So some of the debts will be obvious and you're going to know of, but you may not know of everything. So through the probate process, you have to notify creditors that there is a probate pending and that if they want to get paid, they need to make a claim to the estate. So every probate is going to have this general notice to claimants that is posted in the newspaper, and that lets generally creditors know the probate's pending. But you also have to give specific notice to any secured creditors. So what's a secured creditor? Secured creditor is someone who has a lien on a piece of property. So usually that's a bank that has a mortgage on a house or a piece of land, or maybe a bank that has a lien on a car because it's not paid off yet. Those are probably your 2 biggest examples of secured creditors. They also have to get specific notice of the decedent's or the decedent has passed. You can also give notice to unsecured creditors, and sometimes that's a good idea if it looks like there could be a lot of unsecured claims out there, or in particular, if you think the estate is not going to have enough money to pay for all the debt. So some of who you are notifying in those terms can be looked at depending on how many assets the estate has versus how many debts they have. There is a little bit of strategy there. But generally, you have to let the creditors know that there is an estate open, and then they have to make a claim to the estate, which is evaluated, and then if a proper claim paid. So then let's say you have gone through this whole process, right? So you've gone to the court, you've been approved, you've inventoried the assets, you've paid off any proper claims. And so you're to distribution, right? You are to the point where you are going to give the property to the heirs. So when my sister was almost 16, my dad had this beautiful 1965 Mustang that was kind of a maroon color. And she was certain she was going to get this car on her 16th birthday and be able to drive it around. And for some reason, he decided to sell it. Someone else in town, which really just actually distressed my sister and me and my mom at the time. But anyway, so I bring that up because sometimes there is something like that, right? Like a fabulous car that everyone really wants at the end. So let's say he hadn't sold the car, and when he died, it was still in his estate. And let's say, though, it wasn't just me and my sister, let's say we had another sibling, so there were three of us. How do you practically give a car to three people, right? Let's say that we were the three heirs of the estate. It could be tough, right? You're not going to give one person the front, one the middle, and one the back. And you're not going to do, okay, this sibling gets it Sunday and Monday. This one gets it Tuesday and Wednesday. This one gets it Thursday and Friday, and we alternate Saturdays. Like, it's just not practical, right? So how are you going to distribute this car? The most common way is property that people don't physically want that property is sold and divided amongst the heirs. Okay, so that's one of the probably most common ways that this happens. But let's say someone really wants, let's say my sister is like, man, I've wanted to drive this car since I was 16. I want it, right? So what you can do too, if all the heirs are cooperating and getting along, is maybe you let her take that car, but then you make an equal distribution of that value to the other siblings that are left. So everyone ends up with equal value, right? That can sometimes be a way around this as well. So I bring up this example of distribution to tell you that, in particular, if you have a properly drafted will, there is some flexibility for your executor to do what they need to do to make sure that things are distributed and you don't end up with a funky situation of three people owning a car, everyone fine about it, and no one really enjoying it. Sometimes you will see that in particular with real property. So people say, I want to give my house to my four kids. Well, four kids, if they give that, one of them dies and gives their interest to their grandkids, suddenly you're going to end up with multiple owners, and you can see how quickly and exponentially you can end up with a ridiculous number of people owning a single piece of real property. And that becomes problematic because then those people at some point have to have the fight about how is that partitioned out. So you want to be a little bit careful about leaving stuff to multiple people, but if you do, there are ways around it if your executor wants to take those. So let's get a little bit into the why. And this will also build off that distribution scenario a little bit more as well. So why? You may be asking yourself right now, all right, look, if there is a will and it says everything to my spouse, why in the world do I need to go to court, right? Why do I need it proved that I am entitled to all of this? The short answer is to avoid fraud, right? To prove that it is the final will and testament of the deceased. So that's the biggest and primary reason. But the second reason is for some assets, you are going to need to show that you have authority to act on the decedent's behalf. And the only way to get that is through court approval. So what do I mean by that? Some assets are very easy to distribute, right? So let's say someone dies, they leave a bunch of cash to their kids. Well, that's very easy. You could just give the kids the cash, right? It's not, you don't have to fix titles or anything like that. You could just hand it to them. But let's say someone dies and they leave their kid a house. Well, how you can't just, hand them a house to split up, right? How do you show to the world that your kids now own this house? Or the kids, excuse me, not your kids, but the kids of the deceased now own the house. As you are aware, when you buy a house or a piece of land, you get a deed. So in this case, it's a warranty deed that I'm showing on the screen, but there are various types of deeds. You get a deed that says you own the house, and that deed is recorded with the clerk and recorder or the county recorder in the real property records. And so every time there's a change of ownership in land or house, condos, those sort of things, it ends up in the real property records. And that is how the world knows you own your house, is the real property records, right? Well, if someone dies, how's the world know that they no longer own the house, that they're deceased, and it goes to their kids, right? So a lot of people think, well, I'll just file the death certificate. Well, maybe not, because how can they tell from the death certificate who gets your property, all right? So other people think, well, I'll just file the will. Well, as we've discussed before, it'd be pretty easy for someone to just make up a will and file it on their behalf with the clerk and recorder. And the clerk and recorder really isn't set up to determine whether a will is valid or not. So you really need a court saying, yes, the will is valid. Yes, here's the executor of this will, and the executor has the power to transfer that property out of the decedent's name into the heir's name. So different states accomplish this a little bit differently. In Texas, if you have a probate pending in the county in which the real property is, that may be sufficient for the transfer if the will is very clear on who gets that real piece of property. However, sometimes if the will is not clear, you are going to need a deed from the executor to the heirs saying that they are transferring the property from the deceased's estate to the heir's name. So there are different ways of doing that, but the executor can't take that action without having been approved by the court and without having lawyers testamentary. So they need that in place before they can do a deed, and sometimes a deed is very necessary. And always it's necessary to have something in real property records that shows transferred. Same happens with mineral interests, right? You have to show that those are being transferred out of the estate into the heirs' names. And so really the only way to do that is through a probate. Cars, there are some forms in which you can give your car away by a beneficiary designation in Texas. If you have not done that, however, which is the more common scenario, and it is just your name on the car, the DMV, Texas Department of Motor Vehicles, will not transfer the car out of the deceased's name minus the letters testamentary showing who it needs to go to. So now if there's a co-owner, they might, or again, if you have that beneficiary designation, but otherwise you need to have your letters testamentary showing you have authority to take out the deceased name and put it in the names of the heirs, or to sell it and sign over title to whoever purchases it. And finally, same thing with banks, investment accounts. They are going to require, and like I said earlier, insurance companies and retirement companies, to even talk to you, they're going to require letters testamentary. So much less transfer, they won't transfer anything without the letters testamentary. So you need those to transfer things over. Having just a will is not sufficient. If you walk into a bank with just a will, they're going to say, no, you got to get a probate and you got to have letters testamentary. So Lots of information just thrown at you about what a probate is, but it can be surmised as a process by which you get the deceased assets out of their name and into their heirs' names, and you take care of their final debts. That's what probate is. So there are several types of probate. And so this also gets into, some people are deathly scared of probate, right? So maybe they had, it's usually the people who had a loved one who had kind of a mess on their hands, and the probate took time and is convoluted, and um, it was hard, and they think, I want to avoid probate at all costs, right? And then you meet other people who are like, really? The probate of my mom's estate was super easy. I'm not really sure what you're talking about. So much of how easy a probate is or isn't is dependent on, one, the type, but two, also the circumstances of the person when they die. Okay, so the better they've done on the front end of setting up their affairs in a way that's manageable or easier for people on the back end, the easier the probate is going to be. And it will also then allow for some of these simpler procedures versus the more formal ones. So what do I mean by that? So just focusing on these first two categories of informal and formal. If you're in your will, you have language that allows for an informal probate, then your executor can go through these things that we've talked about, okay, with minimal court involvement, and just get done what they need to get done. And the only time the court will step in, really, in an informal probate is if one of the heirs or creditors start jumping up and down and saying, whoa, 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 your executor or personal representative isn't doing what they're supposed to do, right? Or we think the will is invalid for some reason. So, but normally, assuming the affairs are in pretty good shape and the will is valid and there's no contest, an informal probate, you would go through the procedures that we just outlined, and it's not an overly onerous process. Sorry, I'm blanking on the word I want, but a formal probate on the other end of the spectrum involves a lot more court involvement. So not only do you have to do the things that we listed before, you have to have the court involved in the approval of each step of the probate, including the payment of claims, the distribution of funds, there are accountings. There's a lot more going back and forth with the court in a formal probate. Not only is it more cumbersome and time consuming on your personal representative, which also means that the heirs don't get their assets or get the distribution as quickly, but it's also more costly. So formal probate can be kind of the worst of all worlds and can be difficult and time consuming, expensive. Muniment of title, that is a form of probate, and that's probably the easiest form of probate that you can do here in the state of Texas. Just know that this is not in every state, but Texas does have it. So the muniment of title is kind of like a truncated informal probate where you go to court, you get the will approved, and then you file the order that the court gives you. It's called a muniment of title in the real property records, and you can start transferring stuff, and you're pretty much done. However, muniment of title is only available if there are no unsecured claims of the estate. So if there is credit card debt, if there is last illness debt, right, bills owed because of a final illness or burial, anything, if the deceased died with debt that's not secured, then you cannot do a muniment of title. If it is secured, so think a mortgage on a house, you may be able to do it. Or in a spousal situation, if the spouse of the deceased is also on that debt and assumes full responsibility for the debt, then you may also get away with the muniment of title. But you have to have a fairly simple situation of no debt before you can do a muniment of title. But if you can, It is even simpler than an informal proceeding and can be very quick. Small estate affidavit. This is really meant for those people who really don't have anything. So one, their estate has to be under $75,000. And then second, there has to be no will. If there is a will or the estate is over $75,000, you cannot use a small estate affidavit. A small estate affidavit, if you can do it, is a fairly quick and easy process. So let's say there's someone who doesn't own any real property. Maybe they have a fairly average car and a very small bank account, and they don't have a will. Small estate affidavit may work. And then finally, the determination of heirship. We touched on this a little bit at the beginning. That is when someone does not have a will and you have to go to court and you have to prove who is supposed to get their assets under the laws of intestacy in the state. So probate. Probate is the main centerpiece of probate is the court. To get assets from the deceased name into the heir's name, you have to go through court if there is a will, right? So how do you avoid that? So some people are like, even the easiest form of probate, I just don't want my heirs having to deal with it because they don't have enough to deal with upon my passing without having to mess with this too. So that might be a reason you want to avoid probate. Number two, probates are public record. So when you file your will with the court, it becomes part of the public record. Inventories, part of public record. And maybe you want more confidentiality than that. Maybe you're like, oh, I don't really want people knowing who I left what to, right? That'd be another reason that you want to avoid probate. Convenience, talked about that already, that maybe you want to make it as easy as possible on your heirs. Or maybe there's a money factor too, right? So probates cost money. And oftentimes it ends up, if you have a fairly simple estate and you decide to use some estate planning techniques to avoid probate, yes, you will spend more on the front end to accomplish that. But on the back end, you won't be paying the cost, or your heirs won't be taking out of your estate the cost of the probate. Now, which one ends up more expensive? That all just depends on your estate when you die, right? And that depends on what you own and who's alive and how things are arranged. But typically, if you don't pay it on the front end, you're definitely going to pay it on the back end, and possibly pay it in spades on the back end. So those are reasons to want to avoid probate. So how do you avoid probate? And like I said, I touched on this more in depth in our previous presentations, but I'm going to just touch on it again here. So you can have a trust. If you have a trust that is completely funded, meaning you have taken all of your assets out of your name for the most part and put them into your trust, then a properly funded trust can avoid probate. Okay, so what happens is upon your death, your trustee takes control of those assets that are already titled in the trust name. So he doesn't have to go to the court to have stuff retitled into the estate's name. And then he can distribute or manage according to the terms of your trust. But trusts are often used in conjunction with other things like ownership rights and or beneficiary designations. Those are two other ways of avoiding probate. So if you have an owner with right of survivorship on an account, or like a motor vehicle that I'm showing here, or you have people named as pay on death beneficiaries, for example, bank accounts, retirement funds, investment accounts, even cars, that can avoid probate because those will go directly to those heirs upon your death. The real trick in all of this is to look at each asset, figure out who you want to go to and how it is going to get there. So most estate plans use some conjunction of these to make them happen, to make no probate happen for you or for your heirs in a meaningful way. However, bit of caution. I went into this in depth in the beneficiary presentation. You have to be careful in how you're doing this and structuring it, because you can have unintended consequences, like assets not going to the people you won't really want them to go to, or creditors having some interest in an asset if you've given ownership to someone else that you didn't really intend to happen either. So while all of these can be used, there is some technical rules you really need to be watchful of so you don't have unintended consequences. And then the last thing I want to mention that you sometimes see people use are transfer and death deeds. These are deeds in which you give a piece of property to someone when you die, without using a will. So what do I mean by that? You would sign this deed today, right? So you'd say, I, Dixie Noonan, give my house to um, my sister, and when I die, right? So that's basically what deed says. You record it. I still own the house until I die. But the minute I die, my sister owns that house and nothing else has to be done because this transfer and death deed. Just note the transfer and death deed can cause some issues with title insurance. So if your sister doesn't necessarily want the house, wants to sell the house later, she may have some title insurance issues to work through. Just be aware of that. It's not life ending, but it is something to be aware of because some people don't realize that, and then we'll use these. So there are benefits in using them. They can be kind of a nice, neat transfer, but you need to know what you're walking into, like all of this. So I think that concludes the probate section of our presentation. I have really enjoyed giving these talks over the last 5 weeks. As I mentioned earlier, they are being recorded and put on the library's website. So if you missed one and you want to go back and look at it, it'll be there. Otherwise, thank you so much for attending. And let's see, I'm going to try to stop the recording if I can here. And